What's the meaning of accost in the fraudulent accosting statute? To find out, you have to read People versus Mitchell, but it's 31 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on the case of People versus Mitchell. This can be found at 2022 New York Slip Opinion 03360, published by the Court of Appeals on May 24th, 2022. This is a criminal case. The issue here is the facial sufficiency of a complaint that accuses fraudulent accosting, which can be found at Penal Law Section 165.30, and I'll explain all that in a moment. What you have to understand this case is two things. Basically, what a challenge to facial sufficiency is, and the fraudulent accosting statute. Facial sufficiency essentially is an argument that even if you take all the accusations, all the allegations as true, the argument is it still doesn't make out the charged offense. So that's what a challenge is. Basically, if you accept everything as true, does it provide reasonable cause to believe, that's the standard, that the defendant committed the charged offense? That's a challenge to facial sufficiency. And the offense in this case is fraudulent accosting, found at Penal Law Section 165.30. That offense says that a defendant is guilty of that crime, fraudulent accosting, when the defendant accosts a person in a public place with the intent to defraud that person of money or other property by means of a trick, swindle, or confidence game. So that's the charged offense, and let's see what the facts are in this particular case. This is what's alleged in the complaint. The defendant goes to 48th Street and Broadway in the heart of the theater district and sets up 2 milk crates as a table with a black box and a slot for putting money in. And he's got flyers on top of the box, and he's calling out to the audience, to the people walking on the sidewalk who have to walk past him, help the homeless. And he's blocking the sidewalk such that 75 people have to walk around his box. And a police officer walks up to him and says, "What are you doing here?" And he says, "Well, I'm collecting money for the homeless." And he says, "Well, where's it going to go?" And the defendant says, "It's going to a church on 116th Street. And when the officer says, "Well, what church?" the defendant doesn't know the name. And when the officer says, "Well, who's it going to go to at the church?" the defendant doesn't know the name. And the defendant says, "Well, I'm the president of a homeless outreach organization. Look at my card." And the card he shows the officer doesn't match other identification shown to the officer. And eventually the defendant admits to the officer, "I was planning on keeping most of the money for myself." He's arrested and charged with fraudulent accosting. He pleads guilty to arraignments, and then he appeals. And he appeals on 2 bases, which are interesting. He says, first of all, I didn't accost anyone. Accost means I was aggressively approaching someone. I didn't do that. And the second thing he argues is the statute says that fraudulent accosting has to be done to a person, a targeted person. I didn't do that. I called out to everybody, help the homeless. And to that, there's a dissent and a majority opinion. The majority opinion says accosting does not have to be aggressive. Accosting just means that the person makes people have to move around him, takes an affirmative act that makes people move around him and speaks first. He actually spoke first by saying, "Help the homeless." So he initiated this scheme to defraud by speaking, and he diverted people's movements. And that was sufficient for the accosting element. And with respect to the individual argument, the argument the defendant made that I didn't approach a person, I argued I was talking to people. The majority says, well, the singular includes the plural. So to say person also means people. So if he says help the homeless to everybody, that also includes individuals. But there's an interesting dissent here by Judge Rivera. Judge Rivera has an interesting dissent where she says this essentially is criminalizing free speech. She says accost is such a strange word. And because it's not defined in the statute, let's think about what the actual dictionaries say about it. And she says that there should be some element of aggressiveness, some intrusive behavior involved in accosting. And here he didn't do any of that. The dictionaries indicate aggressive or offensive behavior that directly targets another person. And here he was just saying to everybody, help the homeless. And finally, with respect to the, she essentially also makes this last argument saying, well, this statute basically targets communities, particular communities, minority communities, and that's not really fair. And she finds that it should not be prosecuted in this way and is unlawful as applied. So she says it's not facially sufficient, whereas the majority says it is. Too long, didn't read, 5 minutes or less. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.